Good morning, and thank you for everybody who is joining us this morning. I can see that there are still just a few people just logging on, so if you bear with us for just 1 minute, we can get a few more people joining before we get going. Thanks. Okay, it's just gone 9:30, so we will get started now. Good morning, everybody, and thank you for joining us for today's webinar. My name is Rowan Turrall, and I'm a partner and the head of the dispute resolution team at Boyce Turner. And I'm joined today by my colleague, Sophie McDonnell, who is an associate chartered legal executive in the team. For today's session, we're going to be looking at some of the common issues that can rise in relation to the termination of contracts. It's an area that frequently gives rise to disputes, and so we're going to look at some of the particular hotspots, some relevant case law, and some learning points to try to help you to avoid getting into those disputes. Some of the issues can be headed off at the drafting stage, and others when it actually comes to exercising the right to terminate. So we'll be having a look at both of those as we go through. Although this is down for an hour session, we are going to aim to take about 40 minutes to go through the topics we're going to cover, as I'm sure you've all got very busy days to get back to. But please feel free to leave us your comments or your questions in the Q&A box, and we'll follow up with you after the webinar. You'll also have our email addresses at the end, or feel free to drop us LinkedIn messages if there's anything afterwards that you feel you'd like to get in touch with us about. So the areas that we're going to cover today are termination for material breach, termination for any breach, termination and SOSMA implied terms, termination and suspension for non-payment, and contractual termination versus common law termination. But before we move on to those topics, we're going to start off with a disclaimer, which is in typical lawyers' style, and it's going to apply to all of the issues that we discussed today. And that is that the whole reason that termination is so problematic is that the actual answer to many of the questions that might be posed in these scenarios is it all depends on the facts and the circumstances of the case. Whilst the wording of many terminations clauses might be very similar, the actual application of those clauses is usually going to be fact specific. And there are so many different degrees of behaviour and potential breaches that it's often difficult to say in any particular given case that there are definitely grounds to terminate. More often, you're probably going to be in a slightly grey area where you've got to make a decision one way or another. Slight differences in wording of clauses may also be key to how a court will interpret a particular termination clause in one case compared to another. Having said that, I've got some overarching tips that can help minimise the risk of getting things wrong. A number of wrongful termination cases that have gone to court have arisen because the contractual termination mechanism has not been properly followed. How a contract should be terminated is going to depend on the precise wording of the contract. It may sound obvious, but this can often get overlooked at the critical point in time, and mistakes can be made that would be avoided if the contract and the factual position have been reviewed with you in the in-house team. For example, there may be a provision allowing for termination on the giving of 1 month's notice. A notice might be sent under that provision without someone realising that a separate clause provides that it can only be exercised, for example, at the end of a 1-year minimum term. Make sure that those at the coalface know the critical importance of getting termination right, and that they come to you early enough for you to have an influence on the process, rather than after the event when it may be too late to save the position. You may find otherwise, for example, that a project team has decided to down tools in the phase of non-payment and have ended up putting your company in repudiatory breach of contract. With appropriate advice from you at the right time, there might have been a contractual mechanism that could have been followed that would have allowed for a valid termination. I recognise that termination decisions are often made in a bit of a frenzy, and it's a basic point, but in that time pressure, make sure that you do have a right to terminate. Remember as well to check that the termination provisions are followed. Sorry, I just jumped ahead too far. I just need to scroll back through the slides again. Remember as well to check how the termination provision actually needs to be effected. If there is a provision stating how notices have to be served, then make sure that it's followed. Whilst there might be some potential for wriggle room if you get it wrong, it's far better to avoid having a dispute about whether your termination is effective or not because you've not followed the notice provisions to the letter. You have to check who you have to send the notice to, how you have to send it, and where you have to send it. And I would suggest checking those points as soon as you are triggering or considering to trigger a contractual termination provision, so that you can think about and address any potential issues, such as an unusual service method, at an early stage. Otherwise, you've got your termination notice ready and you've got a problem working out what you're actually going to do with it. Watch out for timescales as well. If your termination clause contains any timescales, then make sure that you follow them. Ensure that you calculate your timings correctly as well, particularly if your notice clause provides that a notice under the contract is deemed served a certain number of days after posting. If you have, for example, to give 14 days notice to remedy a breach before you can trigger the termination provision, and you forget to take into account the time that needs to be allowed for that deemed service, then you're potentially opening another unnecessary can of worms. Remember as well that many rolling contracts will auto-renew unless a notice to terminate is given a certain number of days or months before the renewal date. So watch out for those timescales and ensure that notice is given at the appropriate time to avoid rollover into the next period. Again, check any timescales as soon as you're considering termination so that you can help minimise the risk of getting it wrong. And all of this relies on the final point that I've got on this slide, which is, can you actually find the contract? It never fails to surprise me how many times parties can't find the contract or aren't sure if the unsigned version is the one that they've actually signed. Termination is a risky business at the best of times, and if you can't find the contract, then all the more reason to tread extremely carefully to avoid landing in hot water. Hopefully none of these points will come as a surprise to you, but they obviously do come as a surprise to some, as can be seen from some of the cases that we're now going to look at in relation to termination issues. So I'm going to start the journey through the perils of termination by looking at material breach. And they're going to be looking at this in the context of two recent cases in which the court had to address material breach in slightly different scenarios. Now, the express contractual right to terminate for material breach is one that is commonly seen and easily drafted. However, things can become more complicated when it actually comes to exercising the clause. And the first case that I'm going to look at in this regard is Riverrock European Capital Partners and Harnack and Mersdorf. And that shows that careful thought needs to be given to what will actually amount to a material breach for the purposes of a valid termination. The dispute in question related to a claim by Riverrock to payment following the termination of a consultancy agreement and various connected agreements. Under those agreements, a company which was abbreviated to DREAM in the judgment acted as the appointed representative of Riverrock within the meaning of the Financial Services and Markets Act 2000 in respect of a fund. Mr. Harnack and Mr. Mersdorf, the defendants, were being pursued under deeds of covenant, under which it was said that they had each undertaken directly and by way of guarantee to meet financial obligations of DREAM following termination. The event which was said to give rise to the right to terminate was the striking off of DREAM from the Register of Companies. And this had apparently occurred through oversight after DREAM had failed to file its confirmation statement with Companies House. The notice from Companies House, which had come through giving advance warning of that strike-off if the failure was not remedied, had been sent to Mr. Harnack's home address where it had been overlooked. The dissolution of DREAM itself was not discovered until some months later when a representative of Riverrock was undertaking a compliance review. Mr. Mersdorf took steps to apply for restoration of the company, but in spite of this, Riverrock wrote to the defendants indicating that the dissolution of DREAM had rendered the various agreements operationally ineffective. And I've included on the slide there the wording that was used in this particular case. A claim was brought after that for just over £1.6 million, said to be payable as a result of the operation of the termination clauses. Although various breaches were alleged, the only one that I'm going to focus on for the purpose of today is clause 6.3.1, which again is set out on the slide and provided for there to be termination if there had been a material or a persistent breach. There was no allegation of persistent breach, and so the court had to consider whether any of the breaches said to result from the strike-off and the dissolution were actually material. The judge helpfully reviewed some of the relevant case law, which considered the term material breach, having noted that the concept of material breach has not been easy to define. It just shows how tricky some of these issues can be. He referred to the judgment in Green Deal Marketing Southern and Economy Energy Trading, in which it was stated that the meaning is dependent on the context and is likely to be dictated by reference to the consequences which would flow from a finding that it had occurred. where the consequences would be significant, such as the termination of a contract that has required significant investment of time or resource, something substantial, meaning a serious matter, rather than one of little consequence may be required. He also referred to Lord Justice Jackson's judgment in the case of Mid-Essex Hospital Services and Compass Group, which in turn cited a number of authorities. That included the case of Dalkia Utilities and Celtec, in which it was said, in assessing the materiality of any breach, it is relevant to consider not only of what the breach consists, but also the circumstances in which the breach arises, including any explanation given or apparent as to why it has occurred. He also considered the case of Fitzroy House, Epsworth Street and Financial Times, in which the judge had considered that the phrase material breach in the context of the clause in question connoted a breach of contract which is more than trivial, but need not be repudiatory. And he also referred to the first instance decision in Phoenix Media and Cobweb Information, in which the judge said, materiality involves considering the following: the actual breaches, the consequences of the breaches to the innocent party, the guilty party's explanation for the breaches in the context of the particular agreement, the consequences of holding the agreement determined, and the consequences of holding that it continued. Now, applying the previous case law that he'd looked through to this scenario, the judge stated that a repudiatory breach was not required where there was a clause requiring a material breach. Otherwise, it would add little, as it could be terminated at common law for repudiatory breach in any event. What was needed was a substantial breach, which had to involve serious consequences for the innocent party. And in this particular case, he had regard to the following factors. The breaches here were as a result of a mistake. They were readily capable of remedy. The claimant was not in fact concerned by the dissolution of Dream. Instead, it just used the dissolutions as a means of justifying termination, which it had already decided it was going to do before it became aware of the dissolution. The consequences of the dissolution caused no loss and did not cause any complaints against Riverrock, and it also did not lead to any action by the FCA against Riverrock. There was no reason to think that any further action would take place later on either. There were no other practical consequences of the dissolution that had been identified other than the replacement of the defendants as the lead managers of the fund. The judge therefore dismissed the claim that there had been a material breach under this clause. I'm going to look at the second recent case before I draw these factors together. And the second case was Stobic Capital and Eskin Limited, which was from last year. Although it covers some of the same ground as the previous case, I've included it because it also considered a clause in which a notice to remedy had to be given prior to termination in the event of there having been a breach capable of remedy. Now, this is another frequent point of concern when you're considering exercising a termination clause. This case concerned a management agreement between the parties, and the claimant had claimed just over £4.6 million in relation to retainer, transaction and management fees under the agreement, alleging that a notice to terminate served by the defendant was ineffective, such that the agreement continued to run and the fees continued to accrue. The defendant argued it had validly terminated the agreement and that no monies were due from it, and instead it was owed money by the claimant, which it counterclaimed. Now, I won't go into the detailed background of this case for today's purposes, but I'm just going to look at one of the termination clause and the judge's comments on it, which are of wider relevance to the issues we're looking at today. And that particular clause was the one allowing termination for material breach, which was clause 8.2.3, which I set out on the slide. And again, that refers to committing a material breach of obligations, but also refers to breach being capable of remedy and failing to remedy those breaches within 28 days of being given a notice. The defendants did not give a notice to remedy the alleged breaches of the management agreement, and instead it sought to terminate with immediate effect. It therefore had to demonstrate that the breach was material and that it was incapable of remedy pursuant to a notice to remedy. As with the previous case, the judge would refer to the Mid-Essex Hospital case and said that material breaches are likely to be substantial but do not need to be repudiatory. The claimant submitted that the consequences of breach are an important consideration, as are the terms and the duration of the contract. The claimant also argued that a failure to contemporaneously notify the other party of the matters complained of as being in breach may count as those against those being viewed as material or as justifying immediate termination. The judge considered that the latter argument must be correct, although, as usual, all would depend on the particular circumstances. In relation to whether a breach is remediable or not, the judge stated that the key consideration is whether matters can be put right for the future rather than being obviated or nullified. And on the particular facts of this case, the defendant was not entitled to terminate for a material breach, but they were entitled to terminate on other grounds. So here are a few things to think about when you've got a case where you might need to exercise or draft a termination for material breach. From a drafting perspective, inserting a clause such as this may assist in protecting the parties from termination where the breach is only minimal, inconsequential or inadvertent, but at the same time allowing termination for matters which would otherwise not be serious enough to justify termination for a repudiatory breach. I mentioned in passing the case of Dalkia, in which there had been a failure to pay 3 instalments under a contract totalling £390,000. Celtec argued the breach wasn't material because it concerned only 3 instalments out of 174 over a 15-year period. The judge found that there was a material breach, so Dalkia was entitled to exercise the clause, but there was not a repudiatory breach. This therefore serves as a good example of where such an express termination provision can come to the rescue. When exercising the clause, consider whether you're required to give an opportunity to remedy before terminating for material breach. And if so, make sure you follow the provisions and give the adequate time for remedy before taking any follow-up action. When considering exercising such a clause, we can extract from the cases referred to a number of questions that should be posed to weigh in the balance whether a breach is likely to be considered to be material. This is not an exhaustive list, and there is going to be a tipping point at which it is more difficult to judge which side of the line a breach is likely to fall. Some of the points worth considering are: what is the breach? How has it arisen and what is the explanation for it? Is the breach easily remediable? What are the likely consequences of the breach and how serious are they? Was the breach highlighted to the other party contemporaneously? Lastly, from a drafting perspective, please help those of us who have to advise on the contract after the event by making sure your termination provisions are well thought through. I had to advise on a contract last week where I was looking at the question of termination for material breach. And after including that clause, the subclause then went on to deal with lots of various other grounds for termination, such as insolvency, change of ownership, and those sorts of things. And it was only at the end of those subclauses that I found that there was actually a definition of what material breach meant in this particular contract. If you or your teams are going to be required to operate these clauses, potentially under huge time and commercial pressures, then make sure that you can navigate your way through them easily and can find the relevant bits and pull them all together when required. Now, next up, I'm going to look at a question that, unfortunately, as usual with these things, does not seem to have a definitive answer. But it's the question of whether you can terminate a contract where you've got a clause allows termination for any breach. Those clauses can be seen, but what does it actually mean? If, for example, the customer is 1 day late in paying an invoice, then they're technically in breach, but would that give you a right to terminate using that clause? On the face of it, you could argue that the phrase any breach is not ambiguous and it should be interpreted exactly as it's written. However, there have been a couple of cases which have given some guidance to just suggest that this might not be the case. But there is also a big but, as the court generally, and not just in this context, has taken different views at different times on whether contracts should be interpreted literally. So I've put down on my slide a couple of cases that show the different ways in which the court has dealt with this question at different times. First up, we've got the case of the Antaeus, which was a charter party case and was originally dealt with by way of arbitration. It subsequently went to the House of Lords in relation to the extent to which the court should grant leave to appeal the arbitral award. But the underlying dispute had surrounded the true constructions of the words, any breach of this charter party. The court took the opportunity to reiterate that commercial documents and contracts should be construed in a manner which makes good commercial sense and not by detailed semantic and syntactical analysis if that would defeat the commercial purpose of the document or the contract. The decision has since received mixed reaction in subsequent decisions, and it's often quoted as an authority in texts dealing with this question. But really the real thrust of the case was looking at the arbitration appeal issue rather than concentrating on the any breach question. The House of Lords, though, agreed with the arbitral tribunal that any other breach in this context meant a repudiatory breach or a fundamental breach of an inanimate term or a breach of condition. The next case was the Rice and Great Yarmouth Borough Council case, And the clause in question, in short terms, stated that if the contractor commits a breach of any of its obligations under the contract, the authority may terminate the contractor's employment under the contract by notice in writing having immediate effect. The clause did not characterise any particular term in the contract as a condition, nor did it indicate which terms were to be considered so important that any breach would justify termination. The Court of Appeal found that an argument that any breach of any obligation would justify termination was contrary to commercial common sense. Subsequently, in the 2009 case of BNP Paribas and Wockhardt, Mr. Justice Christopher Clark noticed that there had been cases in which the court had not accepted that any breach meant any breach whatsoever. However, in that case, he went on to say that it was open to the parties to agree that any non-payment or non-delivery shall have that consequence, and that was what it seemed to him the draftsman of that particular contract had done in a carefully drawn standard form contract intended for widespread commercial use. Next up, in Dominion Corporate Trustees and Development Properties, which was in 2010, the clause in question allowed a party to terminate if either party shall in any respect fail or neglect to observe or perform any of the provisions of this agreement by giving a notice at any time after the occurrence of the default. The defendant was required to make a payment of £420,000 on the 16th of February. It didn't do so, and the next day the claimant served a notice of termination. The judge accepted that, stripped of its context and the relevant background, the clause might be understood to mean that either party could terminate if the other party failed to perform any provision, however minor and however insignificant that failure might be. He considered whether this was an interpretation that would involve attributing to the parties an intention which they could not have had, and he decided that this interpretation would flout business common sense. A reasonable commercial person, he said, would understand the clause to mean that the notice of termination could be given if the failure to perform amounted to a repudiatory breach. In 2017, in the case of Vivian Westwood and Conduit Street Development, the court was willing to apply a term to exclude a trivial or de minimis breach, but not going as far as being material or substantial in the colloquial sense. So this case law would seem to suggest that any breach usually does not mean any breach, and in fact, a repudiatory breach may be required in some circumstances to trigger the clause. But I'd question if that is the right approach. Why would you include such a clause at all if that right exists at common law anyway? The trickier point, though, that comes up is that the case law on contractual interpretation, which has happened subsequent to these cases, has seen there being a tension between the contextual approach, which gives emphasis to the factual background and business common sense, and the textual approach, which looks at the normal or ordinary meaning of words actually used, even if this produces an arguably unfair result. In more recent cases, we've seen a move away from the contextual approach towards the textual approach, in which the court has acknowledged in other circumstances that the interpretation of a clause using this approach might result in the contract becoming a bad bargain, but it's not the function of the court to improve that bargain. So I find myself in a position where I probably can't give you an answer to that original question. There is a possibility that you might now get away with arguing that a clause of this nature, provided it is unambiguous, should mean what it says, and that any breach of the contract will trigger it. However, in my opinion, that's still potentially a risky strategy to take, particularly if you are only relying on a trivial breach to trigger termination, and the obligation in question is not clearly a condition of the contract. From a drafting perspective, consider whether a termination for any breach clause is actually going to be useful to you in any particular contract, or if in fact it's likely to cause more trouble than it's worth. It might be preferable to avoid clauses of that nature, if only to prevent yourself from being on the wrong end of a termination and needing to argue that actually you didn't mean that any breach really did mean any breach. Consider whether there are any clauses that you might want to make expressly conditions of the contract. For example, you might want to consider making time for payment or for delivery of the essence, which would then in turn give common law rights to terminate. Although we'll come on to some of the issues shortly, Sophie's going to cover these in relation to whether there's an overlap between contractual and common law rights and some of the problems that can occur there. While it's possible that a court might enforce any breach clause, the safest route, if you're looking to terminate, may be to assume that any breach doesn't in fact mean any breach, and tread extremely carefully if you're faced with only a minor or trivial breach or breaches. But taking into account the increased risk of the court taking a literal or textual approach to interpretation, even if it results in a bad deal for one party, you need to be even more sure than ever that your clauses say what you mean, rather than expecting the court to step in to interpret them what you wanted them to say, or what you hoped that the court would find them to say in the particular circumstances in which you found yourself. And that's me finished for now. I will pop back up again at the end, but now I'm going to pass over to Sophie, who is going to start off by looking at termination and SOSMA implied terms. Over to you, Sophie.
Thank you, Rowan. The next issue we're going to consider is whether there can be any restrictions on an otherwise unrestricted right to terminate as a result of an implied term. There are a couple of important points to note about the case we're going to look at here, which is the Portobello Productions versus Sunny March. Firstly, the contract in question was not pleaded to be a relational contract, such as was found in the case of Bates v. Post Office number 3. In those contracts, there may be fetters on rights to terminate in certain circumstances, so be alive to those types of contracts. Secondly, the claimant here did not plead that the clause in question was subject to a duty of good faith. The case has a celebrity angle that it relates to a co-production agreement for the production of a film version of the Roald Dahl book, Danny the Champion of the World. The claimant is a film production company and the defendant a production vehicle of actor Benedict Cumberbatch and film producer Adam Ackland. The case before the court was a claim for summary judgment of strikeout in respect of part of the defence, which set out the defendant's case on the termination clause in the agreement. The clause in question stated, Portobello, the claimant, may forthwith terminate the agreement if BC and AA cease to have control of Sunny March, the defendant, or Sunny March Holdings Limited, the defendant's parent company, or if either of these services, their services are no longer exclusively available to either of those companies. The judge noted 2 points at the outset. Firstly, that only the claimant had the right to terminate if the conditions were met. Secondly, notice could be given if one or both of the conditions were met. The claimant on the face of it was entitled to terminate on an unrestricted, unqualified basis. The claimant terminated the agreement in reliance on the clause on the basis that both Mr. Cumberbatch and Mr. Ackland had entered into service agreements with other companies. A second notice was subsequently served without prejudice to the first, stating that Mr. Cumberbatch and Mr. Auckland had ceased to have control of the defendant and its holding company by virtue of having entered into a shareholders' agreement with a third party. The application concerned a paragraph of the defence in which the defendant sought to argue that if it was in breach of the clause grants the claimant a discretion. The defendant argued that it was an implied term of the agreement that the claimant would exercise that discretion rationally and in a manner which was consistent with the reasonable expectations of the parties arising from their agreement. It was common ground that there was no significant inequity of bargaining power between the parties, and that the agreement had been drafted with the benefit of legal advice and expertise. As I said a few moments ago, the defendant did not seek to argue that the contract was relational in nature or that an implied term of good faith should be imported into the clause as a result. Instead, it relied on what has become known as a SOSMIR term, that the power to serve notice had to be exercised rationally and in accordance with the expectation of the parties. The expression SOSMIR implied term comes from the case of SOSMIR International Bank Limited in liquidation versus Standard Bank London, and in essence, an implied term that a contractual discretion should not be exercised in an arbitrary, capricious or irrational manner. In this case, the judge considered the requirements for the implications of a SOSMIR term were no different from the implications of any other term. The judge looked at various decided cases following the SOSMIR case. He referred to Lord Justice Jackson's decision in the case of Compass Group and Mid-Essex Hospital, in which he noted that in each authority where a fetter had been applied by the court, the discretion did not involve a simple decision whether or not to exercise an absolutional contract right. The discretion involved making an assessment or choosing from a range of options, considering the interest of both parties. None of the cases up to that point in 2013 in which a SOSMIR fetter had been imposed involved a simple decision whether or not to exercise an absolute contractual right. Looking through the subsequent cases he referred to, Taka Brittani versus Rockrose, in which High Court Judge Pelling said, "In my judgment, these authorities speak with a single voice. Where the parties choose to include within their agreement a provision that entitles one or more of the parties to terminate, the agreement between them, that clause takes effect in accordance with its terms." He also referred to Mr. Justice Pepperell's decision in Essex County Council versus UBB Waste Essex. In this case, he stated there is no scope for implying a so-some term where a contract gives one party an absolute contractual right. Looking at the clause in question in this case, the judge concludes that subject to the court's ability to imply a term, the claimant was given an unrestricted and unfettered right to serve notice if one or both of the conditions were met. Here the parties had entered into a business agreement that gives one party an unrestricted right of termination. The judge concluded that all of the authorities point firmly in the direction that termination provisions that give unqualified right to terminate are not susceptible to the implications of a so-some limitation. The key thing to consider when exercising a right to terminate for convenience is whether the clause gives an express unqualified right to terminate before exercising it. If you want the exercise of a termination clause to be subject to a duty of good faith or a so-some type term, then you should expressly draft the clause on that basis. Lastly, you should consider whether the contract may be described as a relational, in which case the position may need further consideration. A question that often arises is, can we terminate an ongoing contract for non-payment? This starting point, as with all of these questions, is what does your contract say? It is relatively common that there will be a provision that deals with the consequences of late payment. In some cases, that may be simply for providing for the payment of interest, but in others, it will give an express right to terminate. In that scenario, the contract will usually specify a time period within which payment has to be made, and if it is not, notice to be given prior to termination. In this scenario, the position should be fairly straightforward, but you do need to make sure that the contractual provisions are carefully followed, both in terms of the time periods and any specific formalities for the notice to be given. There may be a provision in the contract which specifies that time is of the essence in relation to payment, and if so, and if payment is then late, this will entitle you to terminate contract for repudiatory breach. If, however, your contract is silent about the implications of late payment, then you need to tread carefully. A single failure to pay an instalment under a contract is unlikely to be a repudiatory breach that would entitle you to terminate. However, a persistent failure to pay on time may be sufficient depending on the circumstances. In the case of Alan Auld Associates Limited and Rick Pollard Associates in 2008, the defendant sought to argue his defence on the basis that the contract had been terminated by acceptance of the claimant's repudiatory breach for continuing late payments. The defendant was engaged by the claimant to undertake consultancy work in relation to a contract for the claimant had with the UK Atomic Energy Authority. The defendant's evidence was that between the 31st of December 2004 and the 30th of April 2006, none of his 19 invoices were paid on time. There were substantial and increasing periods of time ranging between 1 and 9 months late, with more than half the invoices paid over 4 months late. By the end of May 2006, the defendant was still owed £21,000. The defendant complained about the late payment to no avail. The excuse given was that the claimant had no money due to late payment of invoices by its customers other than the authority. The Court of Appeal found that this amounted to a repudiatory breach. It referred to an earlier case in which non-payment was not found to be a repudiatory breach, but here it considered that the context in which the breach occurred. This was the defendant's only source of income, the arrangement was comparable to an employment contract, and the breaches were substantial, persistent, and cynical. Therefore, repeated non-payment or a failure to pay all of the contract sum may amount to a repudiatory breach if that failure goes to the heart of the contract. If you think that a halfway house might be appropriate and you'll simply suspend performance until you get paid, then again, you need to tread carefully. In the absence of an express term or one implied by statute, such as a construction contract, there is no right to suspend performance for non-payment. If you do so without a right, then you risk yourself being in repudiatory breach of contract and allowing the other parties to terminate. For this reason, if you are the party that is going to be receiving payment on an ongoing basis and needing to perform services in exchange, it's worthwhile thinking about including a clause in your contract which allows you to suspend performance for non-payment. This avoids you needing to go for the nuclear option of termination, but gives you some protection against the risk of needing to continue to provide resources at a time when your customer's financial viability might be in question. Please be aware, though, that of the potential impact of the Corporate Insolvency and Governance Act and the Insolvency Act before you exercise such a clause, if the company in question is in fact insolvent. Where there's an express right to terminate which arises irrespective of breach, i.e. as well as a right to terminate for repudiatory breach, then you have to consider very carefully which one to exercise. Which route you choose may affect the damages which you're able to recover. In particular, going down the contractual no-fault termination route may prevent you from claiming loss of bargain damages arising from the repudiatory breach. In this case, Phones for You claimed 120 million from EE for unpaid sums due under trading agreements. EE counterclaimed for 200 million of damages arising from alleged repudiatory breaches of trading agreements by Phones for You. By way of a timeline, on Friday the 12th of September 2014, EE notified Phones for You that it would not review or replace the trading agreements between the parties when they expired. That afternoon, Phones for You resolved to appoint administrators. On the morning of Monday the 15th of September, none of the Phones for You retail outlets and shops opened for business. On Wednesday the 17th, EE sent a termination notice to Phones for You. The notice of termination said, in accordance with clause 14.1.2 of the agreement, we hereby terminate the agreement with immediate effect. Nothing in this notice shall be construed as a waiver of any rights EE may have in respect to the agreement. Nothing herein shall be deemed to constitute a waiver of any default or termination event, and EE hereby reserves all rights and remedies it may have under the agreement. Clause 14.1.2 allowed immediate termination upon Phones for You taking any steps for appointed administrator. A quick aside here to note that since the case was heard, the rights to terminate for insolvency have been limited by the provisions of the Corporate Insolvency and Governance Act in 2020, which, although brought in during COVID, remains in force in respect of restricting the rights to terminate for insolvency certain situations. We're not going to cover it today, but bear in mind if you do have an insolvency situation. The important point to note here about EE's termination letter is that it referred only to exercising its no-fault contractual termination right, although it subsequently sought to argue that Phones for You was in repudiatory breach because it could not perform the contract. Nowhere did the notice of termination purport to exercise the common law right to terminate for repudiatory breach. The judge found that reserving rights or not waiving any other breaches is passive. A reserve right is not an exercise right. In essence, EE did not terminate the contract for repudiatory breach. The contract had already been ended before EE purported to accept a breach of the trading agreements, as giving rise to their loss of bargain. It was therefore not entitled to claim loss of bargain damages, and its claim to do so was defeated by a summary judgment application. The case highlights the importance of thinking through the termination options available to you before serving notice, and in particular, what the consequences might be if you decide to exercise a no-fault contractual termination provision, rather than relying on a common law right to accept repudiatory breach. If you want to claim loss of bargain damages, you must clearly communicate that you're accepting a repudiatory breach of contract in your notice of termination, rather than reserving your rights and using a no-fault termination provision. The case of Digital Capital versus Genesis Mining Iceland relates to Bitcoin mining. The nub of the dispute was an agreement between the claimant and the defendant by which the claimant was provided certain regulatory and software services. The claimant brought proceedings primarily for unpaid invoices. The defendant alleged that the claimant was in repudiatory breach of contract and that it was entitled to accept that breach and recover payments already made on the grounds of total failure of consideration. The claimant denied breach and alleged the purported termination was itself a repudiatory breach, which it accepted. There's a long and detailed chronology of events in the judgment, and we won't go through this in detail, but will instead focus on the issues before the judge in relation to termination. The reason for addressing those issues is that they touched on the tricky topic which of the contractual versus the common law right to terminate for repudiatory breach. And what happens when you have a contractual termination provision, but also assert that there has been a common law repudiatory breach. The agreement in question contained the following clause, which is seen in very similar terms in many contracts. You'll see I've noted the clause on the side. But both parties accepted all the breaches relied on by the defendant were material and in principle remediable. However, the defendant argued that the claimant's breaches were so serious that they were not just material, but they were also repudiatory. The defendant therefore argued that it had an independent right to terminate at common law, which was not restricted by the termination clause and the requirement to give notice. It was not in dispute that no notice to remedy was ever given. Here the judge said that on the face of it, the clause applied to any material breach, whether repudiatory or not. If clause 16.1 was looked at in isolation, then the judge said it would have been distinctly arguable that remedial material breaches would only be treated as repudiatory if they were not remedied within 30 days. The construction did not exclude the common law right to termination for repudiatory breach, but simply defined what conduct was required to trigger that right. However, looking at the contract as a whole, the judge stated that the common law right was not circumscribed by the clause 16.1 because clause 16.5 expressly preserved any other right or remedy in respect of the breach concerned. The judge therefore accepted the defendant's argument that if the claimant had committed breaches of contract which were independently repudiatory, i.e. not just simply material, then clause 16.1 could be ignored and the defendant could exercise its common law right to terminate for repudiatory breach. She then considered whether the breaches were in fact repudiatory. As the breaches are fact specific, we won't go into them. Suffice to say that in the case, the judge found that although the claimant was in breach of contract, it was not in repudiatory breach of contract. The defendant was therefore not entitled to terminate the agreement as it purported to do so and was itself in repudiatory breach of contract. As far as lessons to learn go, the judge in the digital capital case stated that the relationship between common law and contractual rights of termination is a question of construction in each case, and there are no hard and fast rules. This makes it extremely difficult to give any hard and fast guidance. The key point to take away is to tread extremely carefully around termination provisions, particularly where you potentially have coexisting contractual and common law rights. You will need to weigh in the balance which option is likely to expose you to the lowest risk, as getting it wrong can have significant financial consequences. In some circumstances, it may be possible to exercise both a contractual right and a common law right to terminate, provided the two are not inconsistent, which may help limit financial exposure for wrongful termination. If you're relying on common law rights, then make sure that you have not been excluded by the wording of the contract. And that now concludes the styles, and I'll pass you back to Rowan.
Thank you very much, Sophie. I hope that you found that useful. We've had a couple of questions while we've been speaking. We will be circulating copies of the slides afterwards, and there will also be a recording of this available should you feel that you need to listen to it again or to share it with any of your colleagues. I'm afraid the other questions I'm going to answer with my lawyer's answer, which were in relation to what the wording of notice provisions mean, where it provides for a certain number of days, and some examples of what would be a material breach. I'm going to come back to my first slide and say I'm afraid it depends on what your contract says and what the particular circumstances and the facts are of the case. So whilst every case turns on its own facts, hopefully we've given you some pointers on the areas where some of the issues can arise to help you try and avoid some of the pitfalls which can arise around termination. As I mentioned, you've got our email addresses on the slides. Please feel free to drop us a follow-up email or give us a call if you'd like to get in touch, or send us a message via LinkedIn. And please do keep an eye out for our future events which we've got coming up. I think our next webinar is due to be a data protection update from our commercial team. And then later in the year, we'll be back with the dispute resolution team providing a privilege update and a look back at the key contract cases of 2023, although I don't want to wish the year away just yet. In October, we are also due to be hosting an in-person event for heads of legal. So again, watch out for the invites for that later in the year. Thank you very much again for joining us and enjoy the rest of your days. Thank you very much.